But then normally, when you do a 2-page sale agreement, you haven't protected your client that well, because you'll find that the dispute resolution clause is not there. The vendor's warranties is not there. Because remember, the search doesn't tell you that this property has a case in court. So at least in that sale agreement is where you ensure now you protect your client from other factors that maybe that your due diligence cannot disclose. Because by that, I was also giving an example of where we had a client who we didn't know the property had a case in court, and we were dealing with these Ivy League firms, the ones representing the seller, and we didn't know that they didn't disclose that information. But luckily enough, we had protected ourselves because we made sure there's normally a clause we put there, the vendor's warranties. But then under the LSK conditions of sale, the vendor is required to disclose these things. Any defects that is not like for instance, the best example for a case, you can't know, like the search doesn't say this land has a case in court. So that's why this is where now the sale agreement, which I normally say is a very important step, is where now you protect your client. And then another thing, people normally, a sale agreement also has to be, remember statutory requirements of a sale agreement. These are some things I remember we covered for students or in KSL, we did them in conveyancing. Like it should be in writing, and then all parties to the sale agreement must sign it. And also there's also the thing that it must be attested to by a witness who was there physically. So attestation can be done by an advocate who witnessed who even drafted that sale agreement. So these things must also be, it's very important, because if maybe the document was not attested to, remember that sale agreement is not valid. Or people normally make mistakes like even not dating the sale agreement. By the time, because let me tell you what happens. Maybe if your client was one who's conned, when you go to court, that advocate, maybe let's say you're the purchaser's advocate and you're the one who your client was conned. When you go to court, what the vendor's advocate is going to do will come and say that sale agreement is not valid. Like that is when what will be focused on, even not the fact that your client was conned. And by the time the court rules that the sale agreement was not valid, you have no case. So it's very important to ensure that the sale agreement is well executed. These are the major factors that should be, like the legal factors. Because even I remember there was some people in the village, they had drafted the sale agreement. It was in Kikuyu, but it was well executed. But no, the court accepted the sale agreement because it had everything. Yeah, it was in writing, and the court interpreter, while not interpreting what was written there, it showed everything was well. Like they said, the purchaser was willing to purchase, the seller was willing to sell. These other factors of the consideration, the contents of like the contractual part. And so these are other factors that, sometimes by there, I'm sure even, I remember when I was in school, I used to, when we were in class, these are things when even you only read them to pass the exam, but when you think about it, you're like, these are things that I don't think someone can. Maybe it doesn't have a lot of impact, but it really does. And also the agreement also must have a contractual aspect. They were saying, like at least you must ensure there's a part that you're saying the seller is willing, the offer and the acceptance, willing to sell, and the purchaser is willing to buy. So that's offer and acceptance. And then there must be consideration. Consideration is the part of course, how much you're selling the property. And then there's the issue of certainty. I know these aspects, the contractual agreement, I think the offer, consideration, also those aspects must be in the sale agreement. And another thing you must ensure is now the contents of the sale agreement. I think obviously the parties, but you must make sure you have described the parties, and then parties by stating their names, their addresses, their IDs, and then there's also the particulars, like for instance, you must describe the property. People also, that's what I was saying, the 2-page sale agreement, you find they haven't described the property. The part where now the description comes in, because I remember there was an agreement we did for a client. She was buying property in these areas of Thika Road. And because for us, at least we made sure we described the property, because later we came to realize there was like, it's something that when the surveyor was doing the measurements and everything, the neighbor had passed the boundary, which was later realized. So at least because we had clearly stated the acreage our client had bought, that helped us. Because if we had not stated the acreage, like we had not described the property, it was easy for the seller to state I sold you, maybe let's say it was 0.08 hectares. I sold you 0.07 hectares instead of 0.08 hectares. So at least because we had described the property, it helped our client because now our client had to get compensation of the part that the other party and like the neighbor encroached. So also describing the property is very important. There's also the aspect of encumbrances. You know, this means like you may want to buy a property, let's say anywhere in Kenya, you want to buy a property, then the seller has already taken a loan using that property, like it's encumbered. So what you do, sometimes you don't have to, like that not should be encumbrances, and a property that is encumbered should not be a reason for you to like not to purchase that property, because you might agree in the sale agreement that the first installment, let's say it was a property worth 6 million and the person took a loan of 3 million and has paid already 1 million, 2 million is remaining. So, and the purchase price, maybe let's say it was that, let's say 6 million. So what you agree that the 6 million will go in, the 6 million will go, the 2 million, you'll pay a first installment of 2 million, but you clearly state in the agreement that this 2 million will first go to offset that loan. So after offsetting the loan, of course, the bank will give you back the title deed. So at least, so that like basically those are things that you should set in the sale agreement. And then there's also the special conditions. Special conditions are basically conditions that are relevant to that specific agreement. It varies from different agreements. Issues like deposits, because you know deposits you pay different amounts depending on the value of the property. Vacant positions also, they differ. So these are just special conditions that will be part of the sale agreement. Basically, it's just relevant to a specific property. Then there's the general conditions that must be part of the sale agreement. These apply generally in case this special condition has not covered it. It's just general, like you're protecting yourself. For instance, you state that, because of course you can't state everything. So what you state, you put a clause like this sale agreement is governed by the Law Society Conditions of Sale of 2015. Now this clearly states in case something happens that was not covered in the sale agreement, at least you've already covered yourself because now you use the law.
Hi. Oh, it seems like
that's basically what the.
Yes, you can proceed. You have like 4 minutes.
No, the other stage. Finish. So and then there's the issue. Then part 2, the final stage, it's obtaining the land control. Let me summarize the part 2 stage. Drafting the sale agreement is not obtaining the be consent and doing the land valuation. Land valuation is like, if for instance, if your land is in an urban area, you pay 4% of the value of the land and 2% of the for stamp duty purposes. So valuation is done for stamp duty purposes. Then after stamp duty, now the transfer is done. And finally, now there's normally the capital gain tax. Capital gain tax is basically the tax that the buyer will pay. It's something that was introduced in 2015, where the buyer pays 5% of the net gain. And it's only payable for properties that over 3 million. So not everyone pays it. If your property is over 3 million is where you pay the capital gain tax. And then finally, there's the postal search. I normally tell people at least ensure you do a search after the transfer has been done, just to confirm the green card. That, you know, your title might be stating you're the owner of that property, but now it's also important to confirm that at least by doing a postal search, you also confirm that it has been changed in the green card. Because remember, people who are there, they are human. You may find there have been scenarios where they forget to change in the green card, so the green card is still reading the seller's name. So if you fail to do the postal search, you'll find like this is something you come to realize when it's too late. So I think, thank you. That is now the legal process in summary.
Oh, thank you very much. So I would open the floor for questions. Raise your hand. I will start. So my first question, I think I have several, but my first question is with regards to professional undertaking. So my question is, maybe if you can speak about professional undertaking and whether in instances of professional undertaking, whether the other party, let's say the purchaser is, so we have the vendor and we have the purchaser. So the purchaser comes in and says, the purchaser's advocate comes in and says, I will undertake a professional undertaking to pay you a certain amount at the completion date. So maybe if you could take us through that process of professional undertaking so that we get to understand what is professional undertaking and what are the implications therein. Thank you. The rest, you can raise your hand and then I'll advise you. Yes.
Okay. So in regards to professional undertaking, but the professional undertaking can either be done by even a financial advocate. Financial advocate, now that means the bank's advocate can give a financial undertaking. This is basically, it's more, I don't know if I'll call it as a, but it's normally put in writing. So the thing is, the professional undertaking should be in writing. It's more of like, it's a separate, it's more of an agreement where parties agree. So let's say, for instance, someone like the vendor will give a professional undertaking stating that I'll give this the completion documents upon the payment of maybe, depending on what you are agreeing. So the vendor will put, like, I'll give the completion. I think the completion documents are basically like the original title, like for the passport photos, the things now that will enable the property to fully transfer to the buyer. And then, but mostly the ones that I normally see in practice is normally financials. The bank normally want an undertaking from the advocate, especially if the bank is financing, like mostly banks finance 70% of the purchase price. Most banks, they don't go above 70%. So they normally want a financial undertaking that this, like, but at the end, so remember the bank is going to check, like, the bank is not going to check the titles. So the bank must, the financial advocate will give an undertaking stating that immediately, like immediately they sell, as the buyer pays this, the completes paying the amount, then they are going to give back the completion documents. And then, yeah, I think basically that. I don't know if people have understood it.
Thank you. We have understood. So Rogers, then Harriet. Rogers, go ahead.
So my question was also a follow-up to what Angie had asked. I wanted to ask on the consequences of not adhering to the professional undertaking. Like, let's say whereby the purchaser's advocate gave an undertaking that once the completion documents were given, they would release the balance of the purchase price. But in this case, they are unable to. So what remedies would there be for the vendor? Thank you.
So no, okay, thank you for your question. So what normally happens at the professional undertaking, you must also state like the remedy that will happen if the other party doesn't like commit to what they had stated. So in the undertaking, you also state the remedy. Your remedy should be part of the undertaking.
Oh, okay, thank you. So in this case, maybe you can say they have the remedy of rescinding the agreement.
Yeah, or keeping, and yeah, rescinding the agreement and keeping a percentage of the amount that has already been paid. Maybe 10% or 20%.
Thank you, Advocate.
Okay, now we'll have Harriet, then Ian, then Tabitha. Harriet.
Hi. Harriet, unmute your mic.
Harriet, unmute. Or are you?
Hey.
Yeah.